Parts of a pleading. The parts of a pleading are caption, body, signature and address, and verification and certification against forum shopping. The caption sets forth the name of the court, the title of the action, and the docket number if assigned. The title of the action indicates the name of the parties. They shall all be named in the original complaint or petition, but in subsequent pleadings, it shall be sufficient if the name of the first party on each side be stated, with an appropriate indication when there are other parties. Their respective participation in the case shall be indicated. So for example, here, Jose Santos is the plaintiff and Peter Poe is the defendant. If there are several parties in the original complaint or petition, all parties must be named, whereas in subsequent pleadings, it is okay to omit the other parties so long as the first party on each side be stated with an appropriate indication when there are other parties, such as the use of the word et al. Next, the body. The body of the pleading sets forth its designation, the allegations of the parties' claims or defenses, the relief prayed for, and the date of the pleading. The allegations in the body of a pleading shall be divided into paragraphs so numbered as to be readily identified, each of which shall contain a statement of a single set of circumstances so far as that can be done with convenience. A paragraph may be referred to by its number in all succeeding pleadings. So for example, in the answer, the defendant can refer to a paragraph in the complaint based on its number. Headings. When two or more causes of action are joined, the statement of the first shall be prefaced by the words first cause of action, of the second by the words second cause of action, and so on for the others. When one or more paragraphs in the answer are addressed to one of several causes of action in the complaint, they shall be prefaced by the words answer to the first cause of action or answer to the second cause of action, and so on. Okay? And when one or more paragraphs of the answer are addressed to several causes of action, they shall be prefaced by words to that effect. Okay? The relief. The pleading shall specify the relief sought, but it may add a general prayer for such further or other relief as may be deemed just or equitable. So in this case, the example provides, wherefore, premises considered, it is most respectfully prayed of this honorable court that judgment be rendered in favor of the plaintiff, and order the defendant to pay the plaintiff the amount of, pay the plaintiff the interest of. Okay, so that is the prayer. And the date, of course, every pleading shall be dated. Next, the signature and address. Question: who should sign the pleading? The rules provide that every pleading must be signed by the party or counsel representing him, stating in either case his address, which should not be a post office box. So take note, the party or the counsel representing him. So in this case, a party may sue or defend an action pro se. Usually, a pleading is signed by the party's counsel, right? Yet, the rules allow for a party to prosecute his case pro se or for oneself or on one's own behalf. The rules provide that the party can sign the pleading indicating his address therein. So let us relate this to another rule in the rules of court. Rule 138, Section 34, by whom litigation is conducted. In the court of a municipality, a party may conduct his litigation in person with the aid of an agent or friend appointed by him for that purpose, or with the aid of an attorney. In any other court, a party may conduct his litigation personally or by aid of an attorney, and his appearance must be either personal or by a duly authorized member of the bar. Section 34, Rule 138 is clear that appearance before the inferior courts by a non-lawyer is allowed. It recognizes the right of an individual to represent himself in any case to which he is a party. The rules state that a party may conduct his litigation personally or with the aid of an attorney, and that his appearance must either be personal or by a duly authorized member of the bar. The individual litigant may personally do everything in the course of proceedings from commencement to the termination of the litigation. Considering that a party personally conducting his litigation is restricted to the same rules of evidence and procedure as those qualified to practice law, petitioner, not being a lawyer himself, runs the risk of falling into the snares and hazards of his own ignorance. So the Supreme Court held in one case that therefore the plaintiff at his own instance can personally conduct the litigation of the civil case. Then he would be acting not as a counsel or lawyer, but as a party exercising his right to represent himself. So in this case, if the party chooses to represent himself, then of course he can sign his own complaint or pleading. Now, what if the party is represented by a counsel or an attorney? What is the effect of the signature of the counsel in the pleading? The signature of the counsel constitutes a certificate by him that he has read the pleading, that to the best of his knowledge, information, and belief, there is good ground to support it, and that it is not interposed for delay. Rule 138, Section 21 provides the authority of attorney to appear. An attorney is presumed to be properly authorized to represent any cause in which he appears, and no written power of attorney is required to authorize him to appear in court for his client, but the presiding judge may, on motion of either party, and on reasonable grounds therefore being shown, require any attorney who assumes the right to appear in a case to produce or prove the authority under which he appears, and to disclose, whenever pertinent to any issue, the name of the person who employed him, and may thereupon make such order as justice requires. An attorney who willfully appears in court for a person without being employed, unless by leave of court, may be punished for contempt as an officer of the court who has misbehaved in his official transactions. Rule 138, Section 22 provides for the attorney who appears in lower court also presumed to represent the client on appeal. So an attorney who appears de parte in a case before a lower court shall be presumed to continue representing his client on appeal unless he files a formal petition withdrawing his appearance in the appellate court. Rule 138, Section 23 provides for the authority of attorneys to bind clients. Okay? Attorneys have authority to bind their clients in any case by any agreement in relation thereto made in writing, and in taking appeals, and in all matters of ordinary judicial procedure. But they cannot, without special authority, compromise their client's litigation, or receive anything in discharge of a client's claim but the full amount in cash. Okay, that is the effect if a party is represented by a counsel. Now, what if the pleading is unsigned? What is the effect of an unsigned pleading? An unsigned pleading produces no legal effect. However, the court may, in its discretion, allow such deficiency to be remedied if it shall appear that the same was due to mere inadvertence and not intended for delay. A counsel who deliberately files an unsigned pleading, or signs a pleading in violation of the rule, or alleges scandalous or indecent matter in the pleading, or fails to promptly report to the court a change of his address, shall be subject to appropriate disciplinary action. Now, another part of a pleading is the verification. Except when otherwise specifically required by law or rule, pleadings need not be under oath, verified, or accompanied by affidavit. However, in practice, even if there is no requirement under the law or the rule for a specific pleading to be verified, it is safe to verify most of the pleadings. Okay, how can a pleading be verified? A pleading is verified by an affidavit that the affiant has read the pleading and that the allegations therein are true and correct of his knowledge and belief. The purpose of requiring a verification is to secure an assurance that the allegations of the petition have been made in good faith or are true and correct, not merely speculative. The absence of a proper verification is cause to treat the pleading as unsigned and dismissible, hence produces no legal effect. A pleading required to be verified, which contains a verification based on information and belief, or upon knowledge, information and belief, or lacks a proper verification, shall be treated as an unsigned pleading. Now let's proceed to the next part of a pleading, the certification against non-forum shopping. But before that, let us discuss forum shopping. Forum shopping consists of filing multiple suits in different courts, either simultaneously or successively, involving the same parties, to ask the courts to rule on the same or related causes and or to grant the same or substantially the same relief. Okay, what are the ways of committing forum shopping? First, by filing multiple cases based on the same cause of action and with the same prayer, the previous case not having been resolved yet, where the ground for dismissal is litis pendentia. Next, by filing multiple cases based on the same cause of action and with the same prayer, the previous case having been finally resolved, where the ground for dismissal is res judicata. And finally, by filing multiple cases based on the same cause of action but with different prayers, splitting of causes of action where the ground for dismissal is also either litis pendentia or res judicata. What are the elements of forum shopping? More particularly, the elements of forum shopping are identity of parties, or at least such parties that represent the same interests in both actions, identity of rights asserted and reliefs prayed for, the relief being founded on the same facts, identity of the two preceding particulars such that any judgment rendered in the other action will, regardless of which party is successful, amount to res judicata in the action under consideration. What is the test to determine the presence of forum shopping? The test to determine the presence of forum shopping is whether in the two or more cases pending there is identity in terms of the following: parties or identity of interests represented, identity of the rights or causes of action, and identity in the relief sought. What is a certificate against forum shopping? So the plaintiff or principal party shall certify under oath, in the complaint or other initiatory pleading, or in a sworn certification annexed thereto and simultaneously filed, that he has not theretofore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency, and to the best of his knowledge no such other action or claim is pending therein. That if there is such other pending action or claim, a complete statement of the present status thereof. And that if he should thereafter learn that the same or similar action or claim has been filed or is pending, he shall report that fact within 5 days therefrom to the court wherein his aforesaid complaint or initiatory pleading has been filed. What is the effect of failure to comply with the certification of non-forum shopping? It is not curable by mere amendment, but shall be cause for the dismissal of the case without prejudice unless otherwise provided upon motion and after hearing. The submission of a false certification or non-compliance with any of the undertakings therein shall constitute indirect contempt of court without prejudice to the corresponding administrative and criminal actions like perjury. If the acts of the party or his counsel clearly constitute willful and deliberate forum shopping, the same shall be ground for summary dismissal with prejudice, and shall constitute direct contempt as well as a cause for administrative sanctions. The certification against forum shopping must be signed by all the plaintiffs or petitioners in a case. Otherwise, those who did not sign will be dropped as parties to the case. Under reasonable or justifiable circumstances, however, as when all the plaintiffs or petitioners share a common interest and invoke a common cause of action or defense, the signature of only one of them in the certification against forum shopping substantially complies with the rule as provided by the Supreme Court in one case. What is the effect of willful and deliberate forum shopping? It shall be a ground for summary dismissal of the case with prejudice, and it is considered direct contempt as well as a cause for administrative sanctions. How about when there is a defect or non-compliance with the verification and the certification of non-forum shopping? As to the verification, non-compliance therewith or a defect therein does not necessarily render the pleading fatally defective. The court may order its submission or correction or act on the pleading if the attending circumstances are such that strict compliance with the rule may be dispensed with in order that the ends of justice may be served thereby. Verification is deemed substantially complied with when one who has ample knowledge to swear to the truth of the allegations in the complaint or petition signs the verification, and when matters alleged in the petition have been made in good faith or are true and correct. How about when there is a defect or non-compliance with the certification of non-forum shopping? So as to certification against forum shopping, non-compliance therewith or a defect therein, unlike in verification, is generally not curable by its subsequent submission or correction thereof, unless there is a need to relax the rule on the ground of substantial compliance or presence of special circumstances or compelling reasons. Now, what are the requirements of a corporation executing the verification and certification on non-forum shopping? A juridical entity, unlike a natural person, can only perform physical acts through properly delegated individuals. The certification against forum shopping, where the plaintiff or a principal party is a juridical entity like a corporation, may be executed by properly authorized persons. This person may be the lawyer of a corporation. As long as he is duly authorized by the corporation and has personal knowledge of the facts required to be disclosed in the certification against forum shopping, the certification may be signed by the authorized representative, such as a lawyer of the corporation. What is the effect of counsel's signature in the certification of non-forum shopping? The certificate is to be executed by petitioner and not by counsel, okay? It should be executed by the party and not by the counsel, unless the latter is specifically authorized to do so. A certification by counsel and not by the principal party himself is no certification at all. The reason for requiring that it must be signed by the principal party himself is that he has actual knowledge or knows better than anyone else whether he has initiated similar action or actions in other courts, agencies, or tribunals. And okay, here is an example of a verification and certification of non-forum shopping. Let me read. The verification part provides I, then the name, of legal age, citizenship, civil status, and a resident of, the address. After having been duly sworn in accordance with law, depose and state that I am the plaintiff and in the above stated case and have caused this complaint to be prepared, that I read and understood its contents, which are true and correct of my own personal knowledge and or based on authentic records. Okay? And here is an example, or here's a certification against non-forum shopping, that I have not commenced any action or proceeding involving the same issues in the Supreme Court, the Court of Appeals, or any other tribunal or agency, that to the best of my knowledge and belief, no such action or proceeding is pending in the Supreme Court, the Court of Appeals, or any other tribunal or agency, and that if I should thereafter learn that a similar action or proceeding has been filed or is pending before the Supreme Court, the Court of Appeals, or any other tribunal or agency, I undertake to report the fact within 5 days therefrom to this honorable court. Okay? So that is clear. Verification and certification of non-forum shopping.